policy that protects speech and innovation. When not advising clients on platform liability, copyright, trademark, privacy, or cybersecurity, she frequently writes about all these topics and more for outlets such as the Daily Beast, Law.com, and Techter, where she is a regular contributor. James, I'm already going to mess up your last name, even though you told me it. Czerniawski?
Chernowski, but that's fine.
Chernowski. You see, I did it. I promised I would get it right, but I didn't. And that's why you don't make promises before people. James Chernowski is the Senior Tech and Innovation Policy Analyst at Americans for Prosperity. Previously, he was the Tech and Innovation Policy Analyst at the Libertas Institute. His work has been featured in the U.S. News and World Report, the Morning Consult, the Salt Lake Tribune, and more. He is also a contributing author to the book Eyes to the Sky, Privacy and Commerce in the Age of the Drone. Ali Sternburg, our last panelist, is the Vice President of Information Policy at the Computer and Communications Industry Association, the CCIA. She focuses on online copyright and intermediary liability law and policy, and is also a contributor to the CCIA's Disruptive Competition Project, DISCO, and an inaugural fellow at the Internet Law and Policy Foundry. It's good to have all four of you on this panel. You guys are all obviously way smarter than almost anyone here. No, I'm playing. But to kick things off, we're here today because it is rumored that the draft language for the House version of the United States Innovation and Competition Act, USICA, formerly the Endless Frontiers Act, might include legislation that could be problematic for online marketplaces. Ali, can you tell us more about the USICA and where we're currently at in the legislative process? And why would an online commerce bill be drafted onto, kind of just placed onto this seemingly unrelated bill?
Thank you, John Alec, for the great question. Thanks everyone for having me. I'll try to answer the first, and the second one is going to be more, a little bit more speculation. So USICA, we've been pronouncing it as USICA. I'm not sure if that's what everyone does. Lots of fun acronyms and often backronyms in DC where, and actually USICA previously was called the Endless Frontier Act, which is like a way cooler, not as generic sounding bill. But so my understanding of how we got here is that some of it came from just general bipartisan efforts to compete with China, and some of the few things that folks in Congress on both sides of the aisle can agree on, as well as some things around the pandemic where the supply chain, especially chip supply and lots of technology challenges there. And then in March 2021, there was this big National Security Commission on Artificial Intelligence, NSCAI. They put out this big report. They had been tasked to provide recommendations to the president and Congress on artificial intelligence, machine learning, other technologies to address national security and defense needs. A lot going on there. I would drop a link in the chat. They seem to not have updated their security, like HTTPS thing, so it keeps saying you can't go to their website right now, nscai.gov. But anyway, there's a lot in there. There's a whole chapter on intellectual property, a lot of actually really concerning stuff in the IP chapter, which we won't really get into today. But Congress decided to try to implement some of the recommendations in this report. As I said, originally was Endless Frontier, and then just sort of there was an amendment in the nature of a substitute, and with all amended language, and that became USICA, and that bill was voted out of the Senate in June 2021. And so now the House is working on their version, and assuming that they're going to probably be pretty different, they'll have to go through conference. And if it's going to pass, my understanding is it would have to be, this is an election year, so likely it would have to be done before August recess. But and people seem to think that the House draft text of the House bill could come out as soon as tomorrow. So And in terms of how why is this bill attached to it? Or because sometimes that's the only way that things related to IP and intermediary issues have tended to pass recently. Just in December 2020, there were a few copyright and trademark bills that were particularly concerning, including the CASE Act. I'm not sure how familiar folks are with some of these, but sometimes these bills just get attached to other bills. They call it like a Christmas tree sort of thing, especially when it's the end of the year in December. But so it doesn't, so those copyright and trademark bills that passed that in that way were just attached to, I think, like a must pass spending bill. This, at least, they might have some connection to the endless frontier USICA view of trying to promote innovation, but I really think that they're attached because they just want their bill to pass, and this has to pass. And so, or this is more likely to pass than some of the other stuff. So people are just trying to add their amendments to the Christmas tree. So that's kind of my understanding on where things are and where things could be going. Definitely welcome other people to weigh in. I'm not sure if I'm the only one based in DC. James, are you here too? But anyway, that's kind of my understanding of where things are and how we got to this conversation today about these really concerning online marketplace bills that we'll get into, the Shop Safe Act and Informed Consumers Act, that may be in the House version of USICA as soon as this week.
Thank you, Ali. And yeah, I wish it was a Christmas tree that brought more gifts that made us happy than makes us sad. Yeah, I would love to hear from the other panelists if you would also love to talk about it. Ali pretty much gave us a great summary though.
I'd just like to add that historically we've thought about how there's a thing called regular order in Congress, that bills are supposed to have a hearing, and then they're supposed to have a markup, and then they're supposed to pass out a committee, and then they're supposed to go to the floor. And if the House and Senate come up with different versions, then there's some kind of reconciliation to decide how to navigate that. Every time you see a bill that's being grafted onto what Ali described as a Christmas tree, that's a big red flag. Why is it not going through regular order? What is the problem that is blocking it? And is this the right way to solve it? So as Ali pointed out, this is not an unusual thing happening today, but it's really a sign of Congress's dysfunction that no longer can do the normal steps we expect it to do in developing good law. Instead, it has to use these kinds of procedural hacks.
Wow, yeah. That really makes us think about kind of how our legislative process is and how it should be and how it ends up running. That's
like someone needs to make like a Schoolhouse Rock, like fair use parody that's like, I'm just a bill, but like if it's an IP or an intermediary bill, it's like it's not how it usually goes. Anyway.
I like that, yeah. So let's move a little on and to talk kind of about how we saw two federal proposals right in the House, and we saw the Shop Safe Act and the Informed Consumers Act. Professor Goldman, give us a rundown quick on kind of the Shop Safe and Inform, their stated goals, and how both would impact online marketplaces, consumers, and third-party sellers. And then let's get the whole panel and kind of talk about it out.
Yeah, and so I believe we're going to talk about Inform a little bit later. I'm going to talk about Shop Safe Act. It is unquestionably one of the more concerning of the two bills. But in my mind, it's one of the worst proposals we've seen about internet law regulation in the last few years. And that's a really competitive statement. There's been a lot of bad ideas, and this is in that level of concern for me, that this is a way of Congress fundamentally reshaping the internet in ways that probably don't make it better or just make it worse. So I'm going to do a little bit of professoring here. Let me just take it all the way back to first principles. So normally retailers are liable for the goods that they sell. And that means that they go and they vet with their vendors whether or not the products are legitimate to sell. They go and get insurance in case there's a problem. And then they do some screening as well to make sure that the products are acceptable for their audience. And this has been the rule for decades, if not centuries. This is a well understood concern, and that relates including to trademark law. If a retailer sells an infringing item or a counterfeit item, we would assume the retailer would take direct liability for that sale. And if they don't want to have that liability, they need to build better screening processes to avoid the risk and get insurance for the situations they miss. Now, what happened is starting in the mid-1990s, we saw the emergence of things that we call online marketplaces. And these are services that allow buyers and sellers to match with each other. And in that circumstance, the seller acts as the retailer, the marketplace acts as a service that makes a match or connection between the transacting parties. Because the marketplace isn't acting as a retailer, those old rules about strict liability don't necessarily apply. And in fact, what's happened over time is that we've seen a deviation from the retailer rules to a different sort of law for online marketplaces. And in particular, in 2010, we had a really important ruling that came out of the Second Circuit called Tiffany versus eBay. And the gist of it was that Tiffany said that eBay was selling, merchants on eBay were selling counterfeit items of Tiffany. And Tiffany tried to deputize eBay to go and clean it up, to control the sales of Tiffany items that Tiffany didn't like. And that went up to Second Circuit, and the Second Circuit said in a really important ruling that eBay wasn't liable based on some kind of generalized knowledge about the presence of counterfeit or other infringing items from Tiffany. And eBay was following a notice and takedown procedure for specific listings. And because of that, then eBay was not liable for those things where it was actually removing the items upon notice. And so for the last dozen years or so, we've been operating under this general principle that online marketplaces should follow a notice and takedown style approach, unlike standard retailers who are strictly liable. Trademark owners don't like this deal at all, and they have lots of objections to it. Let me just mention a few. The first is that it's hard for them to tell which items that are being sold on an online marketplace are legitimate or not. They can do test buys and try and figure it out. But of course, once they've done the test buy, that item is no longer for sale. They don't know about the next item that's currently being listed. They're concerned about things like gray market goods or goods that are leaking out of their channel or that are coming across various selling boundaries that they set up. So they have a way of distributing their products, and the online marketplace can collapse those distribution chains. And that can also undermine things like their price discrimination when they have markets where they're selling a higher price and a lower price. And the online marketplace can collapse those and create more price pressure than they want. It's just time consuming and costly to identify infringing listings or counterfeit listings and then to send takedown notices. And it's like a Sisyphean task. It never stops. You always have to keep doing it. And finally, if there are in fact infringing, especially counterfeit items, consumers might be harmed, and they might hold the trademark owner responsible for that harm, not in a legal sense, but in a brand sense. So they'll say, you were giving me a bum item, when in fact the trademark owner never sold it at all. So trademark owners want to fix all these problems, and ShopSafe is their vehicle for doing that. But before we turn to what it actually says, I just want to flag and make sure that we don't lose sight of the fact there's been a lot of really good things that have happened from online marketplaces that are at risk with any time that we might change the rules. And so let me just mention some of the benefits we get for them. First of all, as I already mentioned, they spur price competition. You can see merchants competing against each other to sell items to consumers. That drives the price down. That's kind of competition can benefit consumers. It also creates outlets for used goods so that items are easily sold back into the marketplace once used. And so that creates lower priced options for people who are willing to accept used goods, and it creates more value for the first buyer that they can actually flip the item. And online marketplaces can help reduce search costs. They can keep it the cost of finding specific items lower than if you have to drive to a store and hunt for a particular item, or if it's not available in your market at all, you can actually get access to it. And it also creates the possibility of creating more liquid markets for what I call the long tail goods. These are goods that have relatively small number of buyers, but there may be enough buyers in an online marketplace that it can actually sustain the ability of those items to be sold. Those long tail items are very hard to find in real space. They might be cost prohibitive, but in an online environment, you can actually create bona fide markets for them. Okay, so let's talk a little bit about what ShopSafe plans to do to all of this. So what ShopSafe says is that online marketplaces would face a species of contributory trademark liability for merchants selling counterfeit goods that implicate health or safety risks. Now, right away, you're saying, hold on a sec. If we're worried about health and safety risks, trademark law is really an indirect mechanism to get there. Why don't we just address those health and safety risks directly, as opposed to using trademark as a proxy for that? But we're going to put all that aside, assume that trademark is an appropriate venue for that to even take place. And in theory, what should happen then is that online marketplaces should say, I see their health and safety risks. I know there might be counterfeits in there. I'm going to do more to try and keep consumers safe. Now, the bill is not going to lead to those kinds of consequences. I can't go through all of it. We're all going to chip in to piecing it apart. But let me just mention a few problems with it. So basically, the bill doesn't clearly define who qualifies as a marketplace. It uses a different term. But the point is, we're not even sure who's covered by this law. It may reach all advertising as opposed to just things that we've considered about as true classic online marketplaces. It doesn't define what constitutes a counterfeit. And we know that trademark owners routinely overclaim what they consider to be a counterfeit might actually be something like a knockoff good or a look-alike or some other kind of product that is completely permissible under trademark law, but the trademark owner still doesn't like it. The bill also misdefines what constitutes health and safety. So pretty much any product that's sold in an online marketplace raises health and safety concerns under the bill's standard. So the bill says basically all goods that are being sold in any place that might be an online marketplace or maybe even advertising that could be counterfeiting if the trademark owner thinks it is, now is subject to this kind of screening, which is basically pretty much every product in the marketplace. So it reaches really deeply into the online commerce sphere. And then finally, to avoid liability, the bill says, hey, you can earn some safe harbor from this particular species of liability. It doesn't apply to any other species of liability, but you can earn it for this particular one. And you can do so by doing 13 different things for us. Now, right away, for those of you familiar with the DMCA, and particularly if you've gone through my class, you know how I feel about this. If there are 13 requirements that the defendant has to show, it's too expensive and cost prohibitive to actually be able to show that. Put aside if you're the most well-meaning actor. You screw up on anyone, you're liable, you don't have the protection that you think you have. That's not really helpful. And it makes litigation very expensive because the plaintiffs are going to attack each and every one of those 13 items. Now, some of the items include that the online marketplace must proactively screen for counterfeit items. This is a new obligation that doesn't exist anywhere in the current law. This is not what Tiffany and eBay required. It was the opposite of what Tiffany versus eBay required. And so you have to think about what does that pre-screening look like, and what kind of or proactive screening look like? What kind of type 1 and type 2 errors are going to come from that? It says that knowledge of counterfeits can come from more than just a notice and takedown notification. It can come from other sources as well, which of course means that's lots of things for plaintiffs to look for to say you knew about this because of something that you could have or should have done. And finally, it imposes a stay down requirement for recidivist merchants. And it basically says it's merchants recidivist, you have to ban them from the platform permanently. Which is also a new innovation, something that I think should give people a lot of pause because of the fact that this has never been adjudicated that they're recidivists, and that might threaten their livelihood and the livelihood of all the people working for them. So I'm going to take my break there as the summary overview. Obviously, there's a lot going on in this bill, but because it's such a radical change to how the Tiffany versus eBay approach has established the current regime, it will change things in really dramatic ways, and I think ultimately in ways that we would object to.
Well, you provided a better primer on that topic than I think most news sites do. So I think you did a great job, and even had I think a Iliad by Homer reference. I would love to hear from especially Cathy on who makes up the proponents for both proposals, and is there currently bipartisan support for ShopSafe?
Actually, I might defer this one to Ali or James because they are closer to the sausage making. But in general, there is clumsiness on both sides of the aisle to decide to just react to everything that is not particularly perfect about the internet, and to want to do something and to be rather indifferent to what it is that they are doing. They want to strike hard, strike visibly, score all the political points. Each side of the aisle is motivated by slightly different a sense of what their constituency would demand. But I don't see heroes on one party or the other. Well, there's individual heroes on both sides of the aisle, and there's also villains on both sides of the aisle as well. But maybe James and Ali can speak more to the particular proponents who are sponsoring this and pushing this and trying to get it attached.
James, I'm going to jump in here.
Yeah, sure. I don't think, at least from my understanding, and maybe you have a different read of the situation, Ali, from your perspective at the trade association. But right now, both the ShopSafe Act as well as the alternative that was brought up at the outset of the conversation, the Informed Consumers Act, are both included in USICA in that bill right now. To my understanding, based off of what we've had with conversations with various people, is that it seems like there doesn't seem to be too much coalescing around the ShopSafe Act, but that doesn't guarantee that it won't get included in the final legislation. There hasn't necessarily been a lot of outreach going and speaking against this outside of limited engagement. But there certainly seems to be more coalescing around the Informed Consumers Act. So there's definitely, I think, an interest, as Cathy said, for members of Congress to want to do something here. Technology policy, as I'm sure many of you guys are aware, is a pretty hot topic right now. So for many members of Congress, there's a huge incentive right now to go and show that they're doing something in this space. So it's something that we're continuing to monitor, and something that it remains to be seen as to whether or not either of these proposals will end up in the final piece of legislation.
Yeah, so I definitely agree with a lot of what James just said. In terms of just kind of who's supporting it on the Hill and off the Hill, there was a hearing last year and a markup last year. And at the markup, actually a number of IP, I don't remember his committee. Yeah, it was probably the IP subcommittee members on both sides of the aisle. As they often do, they'll raise concerns, but a lot of them end up supporting it anyways and saying they'll try to address it later in amendments, which isn't always the most transparent process. But so I think the vote ended up being, I think about a dozen or so members, I think, voted against it, primarily Republicans, and then Representative Zoe Lofgren from California, who might be, I don't know if it's where the law school is located, but she made some great points at the markup, and cited to Eric Goldman's blog post, to a post on Techdirt by Mike Masnick, where Cathy also writes. Cited to some concerns from civil liberties groups like EFF, digital services and startups like Engine and CCIA, where I work. So they were able to raise, put into the record a bunch of concerns from folks, and even one of the sponsors, who is the ranking member, Representative Issa, he also seemed to reiterate some concerns, even though he was one of the sponsors of the bill, and seemed to maybe not understand how different it is from the way the DMCA is structured. But so there were a bunch of concerns raised from a wide range of stakeholders in academia and civil society and industry, and in terms and there has been some great reporting on Prof. Goldman's blog and Tech Dirt. Not as much attention drawn to ShopSafe as some of the other Informed Consumers Act. But then in terms of who supports it, I mean, a lot of this is big brands and retailers who just want to have online platforms and digital services do all of the work to police things. And sometimes it gets tied to safety and keeping consumers safe and children. And there's also just, it's hard to separate it from just general views on the tech industry on a wide range of topics. And so, and maybe a lack of understanding that trying to go after a handful of some of the larger, more prominent companies would actually have a huge impact on smaller companies and the users that rely on these services, especially during a pandemic. So,
yeah, I mean, just to pick up on something I started to say, I'm having a hard time keeping all these bills straight because it's getting mixed up with all the let's kill Section 230 bills directly. It's getting mixed up with all the let's kill the internet indirectly via antitrust. It also seems, and some of it is, I think there's some political support for let us do something to kill all the big companies, and I don't care what it is. And some people might be clever to sort of realize like, well, we can pick up the political momentum we need by going after this thing. And some people might be thinking, well, I got to do something. And okay, maybe I shouldn't have got 230. So I'll do this instead, because they don't see these issues are tied together. But philosophically, they're all getting informed by the same place. These ideas of secondary liability, that a platform must be responsible for everything its user does, no matter how implausible that sort of obligation would be, or how ahistoric it would be given our legal tradition, where secondary liability exists, but up until recent copyright cases, it generally was a lot more conditional. Like it really had to leap over a whole bunch of barriers conceptually before we would make the brother responsible, their keeper. And we're just skipping through this analytically. So even though this bill doesn't like mess with 230 directly, it still messes with the whole concept of should we have platforms available for dynamic and varied uses by their users, because this one says no to that. And so do all the other proposals that have different subject matter focuses, but they're all basically the same thing, just sort of with the different words in them, but the same philosophy that's informing them, and that will hurt the internet for similar reasons. It's all common to all of them.
Cathy, you should write that blog post. That's a really good blog post.
Okay.
Hey, John, if I can just add a couple things. First of all, Representative Lofgren is in San Jose, not actually our district, we're in Representative Conrad's district, but she's an alum of our school, and we're very proud of her because she has done some truly awesome work for our country. I want to pick up what Ali was referring about, the manufacturers or trademark owners and the retailers. The trademark owners, of course, as I mentioned earlier, want the ability to control sales online. They want to be able to veto things like gray market goods where they're selling cheaper in another market, or they want to veto used goods if they can, because those are keeping consumers from buying the new goods or reducing the price that consumers are willing to pay for them. But notice that the retailers here, their perspective is basically anti-internet exceptionalism. They're saying, I have to compete with online marketplaces who are configured in a different way, and I don't like that competition because they have some advantages I don't have. Now, retailers may have other advantages that online marketplaces don't have. It's not like it's a clear win one or the other, but the retailer perspective is we can use this law to basically hobble this major competition that we face in the marketplace. And so once again, we have to be concerned if the proponents have a competitive interest in this, are they using that to actually advance the good of society, or they're using this as a form of basically rent seeking, of some kind of policy making that's really designed to benefit them and no one else.
That's perfect. Hold up, sorry, my cat, it was trying to make a showing. But thank you all panelists. I think you guys set the stage really well for the ShopSafe, kind of the beneficiaries, while also discussing how lawmakers are having various opinions on this, on on this specific type of legislation. And so I think we should move on to the next question, which is, absent any regulatory efforts, what mechanisms do online marketplaces already have in place to protect against counterfeits and retail crime? So what is the industry currently doing? And will ShopSafe frustrate any of those efforts? If anyone can start.
Just generally, digital services, as I'm sure you know, they have terms of service, they have policies online for, and they uphold their policies. They'll have their own unique policies. They might change their policies at times, and so as part of the work they do on so many, like they'll have policies on privacy, on content moderation, on intellectual property, copyright, trademarks, and counterfeits, like all I'm sure like just a wide range of different types of policies. And so part of that will include something on often on like trademarks, counterfeits, unsafe goods, because unlike the DMCA where there is like a notice and takedown regime for copyright, for trademark, there is not the same thing. I know Professor Goldman mentioned the Tiffany v. eBay precedent for the Second Circuit. So, but that has not been, I don't think that's like been codified. It's not nationwide. It's kind of what the status quo that services operate under. But anyway, digital services have a strong incentive to not want bad stuff on their platforms, whether in terms of content or goods. They don't want illegal things. They want their users to be safe and from unsafe products, from all the kinds of bad stuff, and that's both tangible and intangible that might be on the internet. So the services are really incentivized to work with brand owners to have to share information, to take stuff down when it gets flagged. But it's kind of each service kind of has their own system right now because it's not really standardized. And so I think that's one of the reasons that brand owners just want to have something that they have less responsibility and they can just make everybody else comply and take down the bad stuff. But yeah, the services have all kinds of programs where they work to take stuff down, where they'll report stuff to law enforcement, where they have different kinds of reporting tools and et cetera. So it's lots of different types of ways to protect users and protect intellectual property.
That was, yeah, you definitely, I think, talked really well about how certain areas of IP have thought forward and to tackle some of those problems, and other areas there isn't that type of protection. And like how do we go about that is a really important question. I think lawmakers have to answer.
But it seems to sometimes like things that are flexible and allow different services to implement it in different ways can be it's not necessarily a bad thing. So it seems to, my view would be that it seems to be working now, but that might not be everyone's view.
I mean, I think they want magic. Like the services is the bigger the service, the more they're actually doing. It's not like nothing is happening on this front, but there's a limit to how good it can be, because how are you going to know? How are you going to find everything? Like,
and how do you know if it's even
perfect
protected?
Yeah. Platform could be. They're in the business of like facilitating all sorts of sales, which is generally good because an awful lot is cool and useful and totally valid and good for suppliers and good for consumers, and like the good stuff is happening too. So it isn't really a case of like nobody's bothering to do anything. People are bothering to do things, but unfortunately it's just not humanly possible to be 100% perfect. And so they're trying to drop this liability on top of people to say, if you are not 100% perfect, how dare you? You're going to be in trouble. But that sort of, nobody can meet that. So, you know, is it going to chill what they're doing? It's going to chill the business itself of being in the business of providing a marketplace forum for all sorts of sellers to connect with customers. So goodbye e-commerce, because we couldn't do it perfectly.
I just want to pick up on what you said there, Cathy, because I do think that that's the important underlying aspect of looking at what you're talking about with underlying e-commerce, along with like looking at more fringe goods that like Professor Goldman was talking about with goods that might not be able to survive in a traditional brick and mortar setting that can survive in an online marketplace setting. There's an actual economic impact to this assessment that basically these retailers are trying to put onto online platforms, insofar as that there are about, I want to say, 2 million small businesses and third-party sellers that operate through Amazon alone. They make an average of $90,000 a year. The bulk of them probably have a fairly decent split between people that use Amazon's fulfillment services for their warehouses, as well as using their own methods of getting goods and services to consumers that want it. Now, underneath this kind of regulatory regime, right, that's all at risk, because if I'm Amazon, from a liability standpoint, why would I want to go and take on the liability for a third-party seller who I have no way of actually holding them accountable for what's in their warehouse? I don't know if it's counterfeit. So that puts people at risk to not be able to go and earn a living. And, you know, it actually has been quite a lucrative way for people to go and support themselves and their families. I believe, according to one report I saw, the average person that sells on Amazon makes something like $90,000 a year. That is more than the median income of the United States. And that is a significant impact if that's what's at threat here. I think that you cannot understate that enough about the implications for what happens to e-commerce if we go with such a stringent liability regime where companies might not be so inclined to work with third-party sellers, and then by extension run the risk of us not being able to have, you know, access to goods and services that are more tailored to our needs, our unique needs as consumers.
And it does raise a cynical pushback against the proponents of this, where to some extent they want to be able to control their retail channels more strictly. And if you've got these marketplaces where there's different forms of retailers that can put goods and services, and like lawful, but maybe gray, but maybe not gray, or just you've got this very dynamic market, you don't have nearly as much control as you do if, like, well, there's a couple of shopping centers that we need to make sure we've got a retail outlet in. And this is challenging their control, but that's commerce. That's kind of the way it's supposed to work. And, you know, query whether some of the impetus to affect e-commerce like this is, oh, what a shame if all those independent vendors went away. What a shame that would be.
Can I just pick up on something that Ali and Cathy both were talking about? This idea that we have this baseline of retailing where the retailers usually take possession of the goods, they validate that it's a legitimate item, a safe item, and then they take liability for what they actually sell in the marketplace. That's not the only way to sell goods in our marketplace. And think about things like flea markets, a really antiquated way of trying to set up a marketplace. But you think about things like farmers markets and the marketplace vendor creates the opportunity for retailers to sell to each other. Online marketplaces is yet another flavor or proliferation of ways that we can move goods and services in our marketplace. And I think that we get value by having multiple channels of ways for buyers and sellers to find each other and to match with each other. I don't think we want a world where it's only retailers and all retailers. I think that would limit a bunch of our options of ways that we would find disadvantageous. And so some of the problems I have with the Shop Safe Act are really, it's trying to push online marketplaces back to treat them like retailers, and eliminate that diversity of options in the marketplace in ways I think, as I said, ultimately are a disservice to consumers. That's the thing that makes me so mad about ShopSafe more than anything else, is that in the end, consumers are getting some really great options. And if they lose those options, I think we'll all be poorer, not only financially, but in terms of our ability to interact with each other.
You know, I really resonated a lot with, especially what James and Ali, you guys definitely talked about kind of things when it orbited medium-sized to small-sized sellers, and I really grokked with that because it kind of comes down to this idea that exactly what Goldman said. It's like a law that's supposed to protect consumers, but it ends up hurting consumers by making things almost anti-competitive because of it, because the businesses that can deal with these laws are the ones that are already succeeding in the marketplace, and they're huge and they're big. And I think that's, you know, a really good way to wrap up kind of how we think of ShopSafe. And I'd like to go ahead and shift gears and kind of go right into the Inform Act. And to go back to that, Professor Goldman, I think you have another rundown to give us.
Is it me?
Yeah, I think so. If you
Just checking if my co-panelists thought they were going to do it, because I don't want to step on anyone's toes.
yeah, anyone can do it, honestly, any co-panelist.
Let me just take a few words about the Inform Act. The Inform Act is the equivalent of a know your customer style law. What it tries to do is to say retailers, of course, are going to know the vendors that they purchase items from. They're going to have lots of information about them, like where they sent the payments to, and who the business contact was that they dealt with. So retailers know a lot about their vendors. The idea is that we want online marketplaces to know a lot about the vendors that they're dealing with. Now, in this case, the vendors are actually these independent retailers / merchants who are selling on the site. But the idea is that the businesses should do more to vet and validate these people, and then to share some of that information with consumers. So in theory, consumers have better recourse, and in theory, if it's an illegitimate activity, a trademark owner is doing a test buy, for example, will be able to go and pursue them, because they'll now have information about who these people are and how to pursue them. You can look at that in the Inform Act as basically like a gatekeeping function. It puts the online marketplace in the role of gatekeeping who gets access to the consumer base, by saying you're going to have to prove who you are, you're going to have to be traceable and verifiable, so that we can go pursue you afterwards. At that level, you might say, well, not the worst idea in the world. Not a great idea, maybe. And certainly compared to ShopSafe, it's less likely to destroy online marketplaces. So, we would call that better than the baseline if the baseline is ShopSafe. But the question is, what problems does it solve, and what are the consequences of doing this? Obviously, it does things like it raises the cost of functioning as an online marketplace. It also raises the cost for the merchants getting access through that gatekeeping function. They have to now comply with a bunch of things that they wouldn't otherwise comply with. And remember, we talked about these $90,000 a year entrepreneurs. These people are making good money compared to the alternative, but we're not talking about people who have an entire compliance department to make sure that they're checking all the boxes. So we're putting a bunch of burdens on them as well. And there's a bunch of privacy issues about who's getting this information, and what's going to happen to it. And what does that do for someone who, for example, has a home and business at the same location or the same number? And then finally, there's some reporting mechanisms that are built into the Inform Act that talk about how basically, if there's concerns about the legitimacy of activity, there must be a mechanism for people to complain. And those kinds of things sound fine if you're a big company with a phone tree and a whole bank of consumer support representatives waiting for your incoming inquiry. But again, those raise costs, and also those can be weaponized in some pretty significant ways. You can flood them for the fun of it. You can flood them for ways of draining your competitors' costs and so on. So there's a bunch of ways, and then you can flood it with notices that don't really belong there, but might have other legal consequence, like sending a takedown notice. So these mechanisms on the surface, they're designed to be like the kind of thing we expect from retailers, but by imposing them on online marketplaces in a fundamentally different relationship, they just don't really work very well. And they're going to change a lot of behavior in very insidious ways on something that looks like it's relatively minor in footprint.
I would like to complain about this bill. Its overbreadth, I think, impugns any rationale that could be motivating it. It applies to small vendors on a really substantial scale. I mean, it does have thresholds and different drafts of different thresholds, but the thresholds are so low as to basically catch all sorts of mom and pop. The mom and pop stores create privacy interests. Now, one of the drafts of the bills did allow for some shielding of the personal addresses, which is great. But then it's kind of like, well, if you're able to shield some of it, why can't we shield most of it? Like, it kind of, the exceptions disprove the necessity of the actual rule. Like there's other ways of solving the problem. It also heavily over applies to all sorts of goods, not necessarily just like potentially dangerous ones, but a t-shirt, a CD, a book, expressive things where now you've got some pure speech products and pure speech vendors who may be selling things anonymously as the First Amendment allows them to do. And these people would get caught by the law and have to provide their information. And the whole thing is really pretty ridiculous because the pretense of it is that if somebody buys a good that turns out to be dangerous, where do they go for recourse? Okay, fine. They should be able to go back to the source. That's how it should work, not to all the intermediaries, go back to the source. So maybe there's a problem where they can't find the source. Okay, but one of the things is like a consumer could make a choice. Like we could solve this by don't buy a product when there's no identifying information attached to the listing, because then you're taking your chances. You might not ever be able to get recourse if it isn't. It's like, as long as the consumer can make the choice, like, well, there was no, this price is really good, but I can't tell who's selling it, but I'll buy it anyway. You kind of, okay, have fun. You're getting a good price, as opposed to a customer who's like, you know, I want to spend a little bit more because I want the accountability. I want somebody to be able to stand behind it. Then you're going to look for the indicia of the listing and choose that product and that offering. Like, we don't really need the government to solve this problem. Consumers can do it themselves. And we're breaking all sorts of stuff in the process by trying to fix it. So no, this is a bad idea, overbroad. And I think the breadth of what they're trying to do and the lack of tailoring to any specific problem, I just think this is really more of the, let's just stick it to big tech, let's just stick it to internet platforms. And it's not, it can't stand up under its own scrutiny.
Yeah, I want to follow up. I think that both you and Professor Goldman have kind of hit the privacy aspect from two very good angles. And I think that I echo those similar concerns in general. I don't think that anybody on the panel or even these companies themselves, they think that there's not an issue with counterfeit goods. I think that there are already mechanisms in place that hold those things perfectly accountable. I think that the issue of counterfeit goods being sold online, while certainly there, I think it's probably overstated in terms of the proportionality of what's being sold online on any given day. That's probably the reality of the situation here. But I think about the privacy concerns too, because I understand KYC, but I'm not necessarily a fan of it, because I also think, like, especially in this day and age when Americans are actually pretty concerned about consumer data privacy issues, and we don't have a consumer data privacy standard in the United States, that we're pushing forward with a legislation that would actually require this company to collect more sensitive information on, you know, again, small, medium businesses. The breadth of this could capture a lot of people. And we're asking a private company to go and hold on to this information because otherwise they'll be liable for not going and handling that properly. And I think that it's actually quite dangerous, because now you're creating a honeycomb of very valuable information for people that are interested in engaging cyber criminal activity, something that we've seen pop up over the past year and change. And that, again, if we want to engage in this area, it certainly is worthwhile, but I don't necessarily think that the government has to intervene for online solutions. I think that they're very responsive to that because of the original message that came out of brand awareness, brand recognition, not wanting to be that bad actor, because there are serious negative consequences for that, especially when you're looking down the age striations, where younger people are more concerned about companies that, you know, have values that, you know, echo what they're looking for. I think that companies are very sensitive to that, and that they try to go and mimic that as best as they can. But this legislation, I think this is the mark in that perspective. It does go and present some legitimate privacy concerns in the name of just like this veiled KYC requirement.
My co-panelists made really great points. One other thing I would add, first of all, to make it a little bit more complicated, there are different versions of this bill in the House and the Senate, and the House version was reintroduced more recently, and lawmakers addressed some of the concerns that some of the online platforms had, and so I think they maybe addressed some of the privacy stuff around like individual sellers on the platforms, but there's still a lot of concerns. It's also confusing with like the different versions. And then speaking of different versions, there's also a number of bills at the state level. I think one passed in Arkansas last term, but we're seeing online retailers pushing these kinds of bills in, I think, as of like 2 weeks ago, at least 24 states with currently 33 active bills. Some of them held over from last Congress. This includes California. I can drop the bill numbers in the chat for the California residents here, but there are things would be really complicated for online retailers operating on the internet to have all these different standards. Some of them are copies, but as similarly with James' point about privacy, sometimes it's better to have something at the federal level than to try to have this like patchwork of state laws.
Yeah, Ali, I'd actually love to follow up with you on that too and ask if like, so if Arkansas is able to pass its own version, what do you think the likelihood that other states will kind of piggyback off that momentum and pass other versions as well?
Yeah, predicting is hard, but I do know from my colleague who handles state policy, that the prevailing narrative among sponsors of these bills at the state level is we can't wait on Congress to act federally. So there's definitely an appetite to do more legislating, and the state legislatures, a lot of them are just getting back to work. And so we're definitely monitoring these bills closely in like more than half of the states right now. It's a lot.
Wow, that's surprising. It's not surprising because it does kind of remind me of other areas of the tech sector that are being regulated, that states are acting faster than the federal government. I would love to ask the final informed question, which is kind of certain companies have come out publicly in support of Inform. And even though they're kind of, it looks like they'd be the target of that bill, like that bill would cause them to have to disclose a good amount of information. So why might they support it, unlike other online marketplaces?
I think because they want to budget the political capital. It's all terrible, but some things are more terrible than other terrible. So, concede the one where you can sort of maybe afford to concede it. Also, big companies are, an Amazon can just add something to the terms of service and either you put up with it, lister, or you don't put up with it. But smaller platforms who are reached by this bill, but for whom that is a much less pragmatically accessible for them, they're the ones who are going to get hurt. Like there's a lot of incidental carnage that these bills can cause. But I think some of it is they can't fight all the battles because then they'll just lose all the battles.
Got to pick and choose your battleground, as they say. Sometimes you have to give up on certain things. And I'd love to ask our last question to our panelists, which is so this is a lot. This is a lot of stuff going on, and a lot of things that implicate a lot of people, a lot of sellers in online marketplaces. What can we do as law students and legal professionals to make our voices heard when it's so easy to not be able to say anything and so easy to feel kind of mixed in your head about how everything's going on?
I would say it's very easy for you to reach out to your representative. I actually, think that representatives are fairly ecstatic, and there's a bunch of young interns excited to take your constituent call to hear you talk about your problems with the bill. If you were to have any, or just want to talk about it further with them. But, there's no reason for you to hesitate, feeling the need to go and reach out to your representative or to your senator, or in general, just reach out to other groups too, and see where they're at on it and ask questions or write on it too. There's literally multiple outlets for you to go and express yourself in the internet, go figure. And I strongly urge you to go and exercise all of them to the best of your ability.
Yeah, I think it's great for people to get involved, especially people that are not based in DC and actually have lawmakers that represent them. Representation is great at the federal level, at the state level. I put the California bills into the chat that I'm aware of, and yeah, definitely encourage people to reach out. Encourage people to to write about things on social media, to write articles, at all these places that are also depend on intermediary protections. But if there's ways for you to write about it in your classes, or I don't know if Professor Goldman takes guest posts, but yeah, I definitely encourage people to get involved and care about this stuff. I think with your legal knowledge from, it can only, it's a great opportunity to get to practice analyzing legislation and getting involved. So definitely encourage advocacy and activism here.
And some representatives on the Hill are really sort of like feeling like all this political pressure to do something. So if you tell them that you don't want that to be the thing, that might help them, because they're trying to react to, I mean, some of them are doing things for cynical reasons, but some of them are really trying to react to what they think is constituency demand. So telling them what the constituency demand or is or is not might be useful, because that's kind of what they want to step up and do.
Perfect. I feel already just ready to charge into Sacramento, hopefully with a poster and a blog post in hand. Thank all of you for being here and kind of giving me your insight, and especially I think a lot of people would be or just grabbed that wealth of knowledge that you guys dropped in. I think we're at the top of the hour, and I just wanted to thank every one of you, Eric, Ali, James, and Cathy, for coming to speak.
Thank you. This is so fun.
Yeah, thank you for having us.
Thank you guys. Thank you, everyone. And again, thanks to all the ILSA members who helped set up this event and POSO for co-sponsoring.